but they may only be leased, not sold to private corporations. Of course, they may be sold to Filipino citizens. With respect to the submerged areas, they are inalienable and outside the commerce of man. Okay? Only after PEA has reclaimed them may the government reclassify them as alienable and disposable lands, if no longer needed for public service. The transfer of the submerged lands to Omari is also void since the Constitution prohibits alienation of our natural resources other than agricultural land of the public domain. Okay? So remember the important points of the main decision. Of course, there were many separate opinions filed in that case, but of course, just stick to the main decision. All right. Ownership. Remember the traditional attributes of ownership. Generally, what are the rights of an owner? You have the right to use, right to the fruits, the right, yung jus abutendi, that should never be interpreted to mean the right to abuse. There is no such thing. Jus abutendi simply means the right to consume the thing by its use. Okay. Right to dispose, right to vindicate or recover. You also remember the limitations on the rights of ownership. These are limitations which may come either from the state in the exercise of its inherent powers of government, police power, eminent domain, taxation, or this may be limitations imposed by specific provisions of law, like the provisions of the Civil Code dealing with easements, legal easements. This may be limitations imposed by the person transmitting the property. If I am donating property to you, I may impose in the deed of donation certain limitations on your use of the property, for example. In connection with the rights of ownership, you remember the doctrine of self-help under Article 429. An owner or lawful possessor is allowed by law the use of such force as may be reasonably necessary to repel or prevent an actual or threatened unlawful deprivation or physical invasion or usurpation of his property. Only reasonable force should be used. The doctrine can be invoked only at the time when there is an actual or threatened unlawful physical invasion, not thereafter. If the property has already been taken by the third person, you are not allowed to use force to get it back. You must invoke the aid of judicial authorities. One of the best examples in connection with the doctrine of self-help would, of course, be the case of German Management and Services Incorporated. Okay. Here was a landowner. He wanted to develop his property, and so he executed the power of attorney in favor of German Management Services to develop that property. Okay. German Management Services went to the property. They discovered that certain individuals are occupying the property. They are cultivating the property. So, German management used physical force to oust these occupants who were cultivating portions of that property. Later on, they tried to invoke the principle of self-help. Court said, that's not proper, because it is not disputed that when they tried to enter the property, those occupants were already there. They had been cultivating the land for some time. Okay? A party in peaceable, quiet possession shall not be turned out by a strong hand, violence, or terror, according to the court. The doctrine of self-help can only be exercised and invoked at the time of actual or threatened dispossession. When possession has already been lost, the owner must resort to judicial process for the recovery of his property. He cannot take the law into his own hands. I think we can take a little oxygen break at this point.